Hi folks, here we are again on IP. I hope you enjoyed my last video on the Hoi Fong case. He was quite skillfully, without any deep knowledge on IP, to go around all the obstacles and have very good management and efficient management and cheap management, I would say, on IP. I could not go until the very end because I have a limitation of 15 minutes, so I wanted just to add something. He was not only able to make an efficient trademark application and trademark management and enforcement, he also was able to create a revenue stream out of his trademark. You may remember that was hot chili pepper sauce, that what he had as its core business. So revenue stream, he was able to identify, or he was identified by the others, and they came to him to license out his smell or flavor to the popcorn industry. They wanted to have this flavor incorporated into the popcorn, and they asked to use the trademark and the flavor naturally in order to make this. And the same thing for the beer industry. So somebody was identified this as a niche for the beer industry, to get the flavor with the beer mixed and have this on the market, and he needed the license of Hoi Fong to do so. So he was able to create a revenue stream of this hot chili pepper sauce. So it's quite amazing example, I think, an inspiring example for you outside in the world, in simple business model, I would say. Now today is much more difficult. That is Enforcement Day. So enforcement is about the guns, right? So we will take out the guns today. Enforcement is a very difficult issue, so I will try to explain it in simple terms, and you don't need more than this, I say, as a businessman. You need to have a lot of experience if you want to carry out, as a lawyer, for example, the enforcement against others in the IP, but this is something for the businessman, and I want to keep it simple, and you don't need anything more, as I said. Now let's take an example. You have a trademark registered, and a cancellation request is coming against you. So that is the first thing. Enforcement goes both ways, right? It can be used against you, or you can use it against others. So in this case, this example is enforcement against you. You have a registration. Well, you thought you would be sure, but in Europe, this example is repeated here now. In a cancellation request can be entered against you after registration on the level of the European Union IP office. So that is administrative enforcement. Administrative enforcement against you. There are three enforcement possibilities existing. So administrative enforcement is one of them. And administrative enforcement normally involves what is the government agency responsible for the registration of the right. In Europe, we have the trademark and the designs as a central agency. We have the patent, which is also a kind of central agency, but not a kind of giving a central right, but rather a bundle of rights. Okay, so that was civil enforcement. Civil enforcement, you can do it yourself on the basis of your earlier right, okay? And others can do it on the basis of their earlier right. The important issue and the stress is here on earlier right. You know this already. First to file, right? That is an important lesson which you know already by heart. So that was the administrative enforcement. Then you have the civil enforcement. So if you want to have some claim damage, you want payment of what has happened against you, for example, then you cannot go to the government agency. The government agency is not able to give you that. What you need is a civil litigation. So litigation that sounds rather costly already to you, and soundly so, rightfully so. That is something which you have to do in the courts and not on a central level in Europe. That would be on a national level. We don't have central courts for damages for IP, etc. That doesn't exist. We have a European Court of Justice, but not for civil litigation, right? This is still in the competency of the national member states. So something you can use the courts in order to get you something, or the other way around, that somebody wants a claim against you. This is civil enforcement. Now, the third would be a criminal enforcement. Criminal enforcement, that is now the guns, that involves a national, not a European, a national instance like customs, like police, like any special IP unit within the government structure, which helps to shut down, to seize, well, this competency, and to condemn, to go into jail, whatever. That is what the criminal enforcement is for. So criminal enforcement, that could be an issue, for example, that you know that somebody is importing some merchandise, counterfeiting merchandise into Europe with, I don't know, a big container, and you have some intelligence on it. Then you would go to what would be the relative competent customs agency in that port, and you would give the intelligence on the date and on the ship's name, and if you have the container identification, and then they would be able to seize it with that information. So in that case you would be at the origin of a criminal enforcement, or you would go to the police, and the police would, by saying that there is some counterfeiting material, you have your trademark, you have all your information, and there's counterfeiting material in that distribution chain or in that retailer or whatever, and you would seek that this is being shut down. So that would be the criminal enforcement. Now, all of the enforcement, that is not good, right? That does not sound good. No, it is not good for your business. It is defending your business against the bad guys. And, well, you have to do it in the administrative way. And you will have to defend yourself also in the other areas. But the good news is, there are some alternatives which you do not need to go to lengthy, bureaucratic and costly proceedings, but you would be able to do it in another way, which is more focused, more cheaper, and it would be not so lengthy as these other proceedings. Now let's have the example that you have seen a similar trademark. You can go to the proceedings of the government agency, in this case the EU IPO, or perhaps the National IP Office, where it is. And there is, for example, a German application, and you have an European-wide registration, so you can go to the national office in order to avoid that this is being registered all on the national level. So there's a bit overlap between European and national level. So the European right gives you the possibility to oppose a national application. Now, you can also negotiate. You have perhaps your lawyer, or you're on your own against that company, and you can negotiate that company will change a bit its application in a way that it does not anymore confuse the consumers. And then you would skip all this lengthy procedural part in front of the government agency. So I think that would be a good way, or if it is already on the market, you will make a cease and desist letter by saying that your right is earlier and it is too confusingly similar to the other later right, and then the lawyers can negotiate one or the other way out, so that both parties get what they want, but still they do not need to go through these lengthy proceedings. Another way would be mediation. I don't know whether you have heard about mediation, but mediation is a possibility also in Europe. It is in fact the EU IPO, the government agency in Europe, which offers free of charge a kind of mediation for IP rights. But mediation exists also on the WIPO level, so the Geneva-based international registration proceedings agency. So mediation has various advantages. It's not as expensive as it would be litigation. It would not be as lengthy as litigation, because there's only one instance, one mediator, one decision, and there is no appeal possible. And well, it is also possible to regroup a more complex relationship you might have with your competitor. If it is only one trademark, and then, well, that's okay. That can be sorted out easily by the government agency itself and its proceedings. But if it is that you have 3 or 4 rights and claims and damages and whatever other issues you may have, so a combination of problems, of legal problems with another competitor, with the defendant, then it would be a possibility that everything is regrouped and everything is solved by this one proceeding. So I think that would be a good possibility to get out of something which is very complicated. Now, it is not very much used, although it is free of charge by the EU IPO. It is not free of charge by other agencies, and you may do it also, well, you get to the mediator by common agreement, right? It is not that, and the other must agree to the mediation. So there are some conditions which must be met in order to avoid the lengthy proceedings. So enforcement, you do not want to be too much implied in the enforcement, although in the mediation you would be. But what is important for you as business is to look what is doing the competition and to identify as soon as possible these problems which might arise. And you want to avoid enforcement by better having a look at what you want to register, so what is on the market, in order not to be enforced by other companies. Or you want to look at the market, what is being registered, etc., in order to closely and timely oppose your right against the others, because once the other is on the market for 2 or 3 years, it gets much more complicated in order to sort this out. Then you have damages and you have any other issues in the middle. So you want to avoid this. So the precautionary measures, I think, for you are the most important ones, and the alternative dispute resolution is the other. So hopefully enforcement easily explained, that worked out. Thank you for tuning in.